Karibuni. I can see Dr. Nelly is logging in, so we'll allow her to do as much. Meanwhile, I will be sharing my screen, and Martin, please confirm that I can be heard and that my screen
Yes,
can
I
also be
confirm.
seen.
Yeah, I can see your screen.
Yeah. All right. My screen can be seen, yeah? Martin, just confirm my screen can be seen.
Yes, I confirm. Documentation.
All right. Awesome. All right. Karibuni, everyone. Martin, also just allow that people can enter their questions or queries in the Q&A section of the webinar. But also importantly that participants can also see who is attending this particular webinar. On board with me is Dr. Nelly Bosire, who's a member of the Disciplinary and Ethics Committee. My name is Dr. Theuri. I serve as a council member at KMPDC, who's our regulator, and I chair the Disciplinary and Ethics Committee. My day job is with the Kenya Healthcare Federation, where I have the privilege of serving as the CEO. The reason I thought we do this particular webinar is because of the intersection it carries with the various roles that I do play. Martin will also alert me if Dr. Gakombe gets to join us on this particular call or any of the members at KHF as well as KPDC. This particular the next maybe 1 hour, we'll be discussing documentation in the care of patients, duty of care, and what we have seen as standard operating procedure. Over the last 1 year where I have been the chair of this particular committee, these are the 3 things that have stuck out where we are causing offense, if I may say as much. So this webinar is largely targeted at clinicians as well as facility operators and owners. So that's where we are going. So I will quickly give a short summary of why we are here. So about KMPDC, the process, and some sample cases that Dr. Bosire will take us through so that we can see how these 3 aspects of care are elicited. KMPDC is the regulator of medicine and dentistry in the country, as well as facilities, and is a state corporation that was birthed by the CAP 253 Act, enacted in 1977, and then became effective in the 1st of January of 1978. Do receive apologies from the registrar and CEO, Dr. Kariuki, who would have loved to be here with us, but given the share rollout, then is currently hopping onto a meeting to deal with that aspect. I will skip the vision, and one of the core functions is establishing standards, and that is what this largely this webinar will be under. Minimum requirements, categorization of facilities, accreditation, and more so the practice of dentistry and medicine. We do have a regulatory framework, assessment and enforcement, as well as advisory to other organizations within government on matters health. The composition is, as you can see, a chairman, a CEO, the DG sits there, someone representing private sector, a representative of universities, KDA, KMA, and the rest are, as you can see. I will brush through this so that we are able to get to the groups of the matter effectively. We have 4 standing committees: training, assessment, registration, and human resource committee. We have an inspection, licensing, finance, and general purpose committee. Indeed, we do have the disciplinary and ethics committee, the one that I do chair. And interesting enough, it is the committee it is the only committee that is embedded in the Act itself. We also have the Audit and Risk Committee. The State Corporations Act mandates at least 4 of these committees to be there, and that's why you see them as such. We do have ad hoc committees. We have an examinations board. We have a peer review assessment committee that will look at specialists who want to get into the country, fitness to practice assessment committee, professional conduct committee, and a CPD accreditation committee. When it comes to the medical legal complaints, largely brought to us by members of the public and our patients as we see them, as well as matters of public interest, maybe through the Senate or the National Assembly, there is a process that they undergo. And the process looks like this. There's a lodge of a complaint, and the case file is opened. These are generally automated processes once the complaint has been lodged through the KMPDC ERP. Respondents are given an opportunity to submit their complaints. After that, we begin the complaints review process. So my committee will sit down. We will send the matter to a subject matter expert. Say, for instance, if it's an obstetric case, Dr. Bosire may be one of the people who receives this complaint, and they will review this matter and assess if it merits. And if there's and once this has been done, what we call the case summary under the review by an expert, we deliberate on it as a committee, because we know medicine and dentistry, they are not sciences of exactness. Therefore, an opinion is needed. And then we will assess documentary evidence, then we will hear this matter. And if we think there is a case to answer, then it proceeds to full hearing. So we will hear the matter where the complainant will come, give us the case. The respondent is also there. It could be the facility, it could be the doctor, it could be both of them. And sometimes we do have many other parties involved. So for instance, if it's a case that had a pathology component, then the lab that dealt with this, or the pathologist who maybe would have dealt with the samples, would get enjoined. If in the unfortunate event there is a death, then the people who carried out the postmortem for either party again become enjoined in this particular matter. Then the committee will retreat upon the ending of the full hearing, and we will give a ruling. So the ruling could take various forms. We could decide on a reprimand. We could think there's a case to answer, then issue various judgments. So there could be a fine. We may take a license if the case is serious enough, or it could be a combination of all those matters. Then we'll also ensure there's verification and compliance with the ruling that we will have given. I will go back again to the reasons that we largely see as at the DEC committee. Allow me to, when I say DEC, it means the Discipline and Ethics Committee. So we do have issues with standard of care given or not given, because when the public, members of the public come to us who are your clients, they will come because they felt aggrieved. So it will be made with a perception of the standard of care you gave. If you've deviated from what is considered a reasonable practice, if you're outside of your scope, misdiagnosis, mismanagement, negligence, these are all matters we get to see. Another issue that I will talk to later is informed consent. And this is the first step. This is what we initially look at. Did the patient understand what you wanted to do? Did they fully comprehend? Were they given an opportunity to refuse? So all those things do come into play, up to and including documentation of this consent. Communication with our patients. This is a significant bone of contention, because I don't want to believe that patients feel a certain type of way when you don't talk to them properly. And at times you could be the best meaning technician, but you're not talking to your clients in a manner and at their level. So we usually see many of these cases. And always remember that communication happens on the listener's terms and not on your terms. So even if I was your client and I am a doctor and you think I have a better understanding of what you're trying to explain, ensure that I do understand what it is you want me to know. If you're a facility owner, these things are very important. The reason I say that is because the duty of care is a shared responsibility. So we will assess as well, have you ensure that your doctors are talking to the patients well? Even if you're a hospital with admitting rights and the doctors are bringing their own private clients, it's important that this communication with your clinicians is had. Because when it comes to the disciplinary process, you will not divorce yourself and say this was a private patient and you don't want to get out of it. No, it is a shared responsibility. So it is important that you do ensure your doctors are talking to your patients well, they are taking informed consent, and they do understand the standard of care you expect of them as a facility. All these are good to be on paper. We will go a further step and ask for evidence of dissemination of the same. You may have this all in the facility, but did the clinicians have an opportunity to have this given to them? So we'll ask for that evidence of dissemination should you tell us that you have done this. A lot of miscommunication happens, especially between health professionals. Consultations, referrals, were they written? Did I deem the person who I'm sending the patient to have understood what I was saying? All these matter. All these matters come into play. Coordination and continuity of care, was that compromised? I've come with my own patient as a doctor to your facility. A patient has complicated and I have called in another colleague. It is my duty as a primary physician to ensure that even when I hand over the patient, that care is continuing. So all those things must be understood very, very well. Follow-up and feedback, it still remains our work as clinicians, and where this has not been done, you may be found to be culpable. Results of samples taken. You send your patient you send some samples for histology, for example, and you're an admitting consultant or you are the resident consultant. Did you follow up with the lab to see whether the results came in? And it's important also as facility owners to have a notification mechanism with your clinicians so that at the end of the day, they are able to know that the results have come in and for them to follow up now on the next steps. Always remember radiology, films and records, as well as histology, or rather samples taken for histology and such like work. Those are records and we expect them to be kept. And it is your responsibility to do so. However, whereas you may retain possession, ultimate ownership belongs with the patient. I hope that is clear. Billing and overcharging are things we see, disputes around this, as well as documentation interactions. I had talked about this particular process. In terms of the number of cases that we do have, we have about 1,000 now 600 and I think maybe 50 cases that have been lodged at KMPDC, and bulk of our cases are pending because of facilities are not giving us the documents when we ask for them. So there will be remedial measures around this. So if you're a facility and KMPDC has requested for a file, has requested for a record, please ensure that you have remitted it, because very soon there will be some measures applied so that these files can be recovered, up to and including withdrawal of licenses and a register for facilities that have not done this. So please ensure that this happens. 25% of the cases that we do have are obstetric and gynecology cases, and a significant portion of the cases we do have do come from the surgical and anesthesia disciplines. The rest remain distributed among the various other disciplines. I will, in terms of responding to queries, complaints, it is important that we give patients the information they need to know. It is important we remain trustworthy in our communication because this is a relationship of trust, and it's almost inclined upwards towards us as clinicians and the facilities that patients do come to. It's important that you provide all the information that is needed to our patients, and they must also understand what is a complaints system like in your various facilities, up to and including coming to KMPDC. Sanctions, I think I had touched on this. So we have various things that we can recommend and do. Remember that KMPDC engages in a quasi-judicial process, meaning that my committee has the powers to reach out and find further information up to and including with other regulatory authorities in the sector. All the staff within your facility remain are within our reach, and we can give a cautionary reprimand in writing, where if we feel that that is what is required, we can recommend that the practitioner undergoes remedial training. We can recommend that they are placed under someone else to work under sort of a probation of sorts. We can suspend, withdraw, cancel a practicing license for up to 12 months, and then thereafter we will send you to the fitness to practice committee. We can suspend or withdraw, cancel the license of an institution. We can direct that the respondent and the complainant go to mediation and agree there. We can also impose a fine, and we can also remove permanently from the register a facility and the practitioner. That part was supposed to be covered by the CEO. I'll come to what I was to cover, and this comes to documentation. So in this process, like I've mentioned, you can hit a quasi-judicial process. At times, we do have lawyers involved. So should you be a complainant, you have the right to legal representation. You can come in with your lawyer. If you are someone who has been brought to us, you have the right to also come in with your lawyer as a practitioner or as a facility if you've been mentioned as a respondent or as a party that is of interest in this particular process. My observation has been, whereas we do have good quality legal representation, our lawyers do not understand hospital or medical operations. So if you have a counsel on retainer, it's important that from time to time you update them on the various things that you do as a facility in your day-to-day processes so that they can understand what is going on. Many a times I see lawyers who've been picked, and they are excellent lawyers on conveyancing matters, matters of land, commercial law, but barely understand hospital medical operations. So representation, you may have a good case, but not well represented. You may have good defense, but not well brought out. And it is my work to deal with what I am told. I can't deduce much as I may think this is what probably happened. So I deal with what I am told and what I have been shown. So it is important that that comes to place. Remember, medicine is not a science of exactness. So documentation is really important. We have seen facilities, we have seen clinicians forge documents, add on notes, and it may seem like a clever thing to do, but please don't do it. We can tell. And the reason we can tell is because you cannot cheat physiology. There are things that you just can't cheat. So you can't come and say that you reviewed your patient every hour, yet what we can see recorded as vitals are going down. So it either tells us that it was not done, or if it was done, you are not attentive to some of these things that were shown. So don't do those things. Just ensure that when you're giving your care to your patients, you are documenting. We do understand things do go wrong. And even when they do, it is our work to assess whether this was maybe something that could not have been prevented. It was a procedural error, which do happen. And we have that capability to assess that. We do send some of these things to third parties just for independent opinions, and it does go a long way in assisting us. The work of documentation as well is to improve the quality of care. Any facility or any clinician who has been involved in any quality accreditation process knows the importance of documentation. So it helps us give us good quality care. We are able to assess what has gone wrong, what we are doing well, what indicators we can watch better. That is the importance of documentation. It also assists us with continuity of care. Where a patient is being seen by multiple clinicians, they are able to see your thought process as a person who maybe last saw the patient. It also gives you legal protection. Top of this is things like informed consent. It doesn't matter how good a procedure you did. If we get the file and there was no informed consent, or if the patient tells us consent was not given, it doesn't matter. It fails there and it falls there. When it comes to accurate billing and reimbursement, documentation is also important. It also helps us track patient improvement. You're able to tell as a clinician whether your patient is improving or not, and whether you want to bring in a different set of skill into the care of this patient. It also helps us note important events in the patient care. Say, for example, you had difficulty in dissecting an abdomen during a cesarean section. Note that. We've seen people who say this was a fairly straightforward procedure, but you find in their notes that they are saying that it was a difficult appendix to reach. So we are able to correlate. It helps you have some protection as well if you wrote very well. The other thing with documentation, say for example, you have this CPD, for example, that we are doing, that you've asked your clinicians to attend such a continuous professional development. You've given a memo. Such things become very important, because if this same clinician lands on our door and we find them culpable, then it means you have done everything within your power, maybe to ensure that they have the right information when it comes to patient care. And you can give a memo showing that you've done this. And later maybe you've asked them to give you some evidence that they did attend such a forum. So attendance registers for such CPDs, where they are physical within your facilities or elsewhere. If you send them for further training and learning, have all these things documented. If you're a clinician, if you attended these things, again, do keep a record of them, because at times we do have unscrupulous facility owners who will come and say that this was Dr. Theory's matter, we have nothing to do with it. Yet at times you find facilities did not keep a good record of equipment repair and maintenance, and the anesthesia machine is not performing optimally. You don't have visibility of such things. So it's important to also note some of those small things because they tell a bigger story. When it comes to consent must always be informed. I will repeat this. Consent must always be informed consent. Again, like I said, it doesn't matter how good a clinician you are. It doesn't matter how world-class of a facility you've operated in or you're working in. If there is no informed consent, that treatment has failed ab initio from the beginning. And I will read it word for word. It is the legal and moral requirement rooted in the principles of respect for persons and their autonomy. And it requires the individuals be given an opportunity to choose what should and not be done to them. And it has to be informed, there has to be an element of understanding, and there has to be voluntariness to them, to that consent. So a patient must understand the procedure that is being carried out on them. A patient must understand alternatives to that procedure. Are there any other alternatives? Are there superior alternatives, or are there inferior alternatives? And the reason why you've elected this one. They must understand your capacity and your capabilities as a clinician. So this is the best form of treatment that is available, but my technical expertise limits me to one that is below that. A patient must know that. Don't oversell yourself. In cases where financial considerations are being done, discuss that with your patient. And now here we begin to have cases where maybe a patient comes when they are not conscious, who gives consent to them. And Dr. Bosira will touch on this a little later. Minors who can give consent for them. And Dr. Nelly, please note those things I will throw your way. Who can give consent on their behalf. Have you requested and told this particular patient, when you go to the table, can they allow you? Should you find anything else that you think is medically important to be done regarding this particular procedure? Can you go ahead and do it? It's important to have someone else witness this, more so any of your clinical staff who is around. We have seen cases where patient relatives have been invited into the room by over-enthusiastic clinicians to witness this process. You must ask your patient to give you permission for that, because remember, you are discussing medical conditions. And it's the person who can give permission for disclosure of that information. So if you want maybe my wife in the room, it is important you ask me. It cannot be a foregone conclusion that she should be there or the husband should be there as the process of consent is happening. It must be done voluntarily. For example, you've discovered in theater that this patient may need an additional procedure. You cannot take consent in the precincts of theater because there is an element of undue pressure or coercion to it. Wheel out your patient. You may want to take a minute or two and ask them whether they feel okay to take those decisions, and they take those decisions. If there's been any slight confusion, maybe you were to do a right nephrectomy, and there's been some slight confusion and people wondering whether it is left or right because of the siding of the imaging and all those things, please cancel that procedure, do it on another day. Because if anything comes out of, you have an event out of it, then those small things come into play. We do have recommendations on how an informed consent should be like, and they are on our website. And this is a list of things that the patient should know. Of course, their medical condition, purpose, and intent of the benefits that your treatment is conferring them. The benefits must always outweigh the risks. The risk of the complications, do you anticipate any adverse effects? If these adverse effects happen, what is your mitigation plan? Those must also be very clear to the patient. Alternative treatments, if it's a test, if it's a procedure. So have all those in the know of the patient. Consequences of not accepting, what is your plan for post-op care, and a statement offering the patient an opportunity to ask or withdraw consent. I think I have explained this. The only thing I will mention here is ensure it's in a language that the patient understands, because like I said, communication always happens on the listener's terms. And then again, allow for questions. Voluntariness, I think I've talked about it. Validity of consent, it can only be given by a person who the law also again considers to be capable of making a decision. It can be given by the patient or their guardian or a proxy who the patient has appointed to take some of, in writing, medical decisions on their behalf. And they've also received sufficient information. We do have cases where religious practices come into play. Say, for example, if you come from a religion or a sect that does not allow for certain kinds of treatment like blood transfusion, what happens? So it is important that when you're taking your medical history, those things are not asked just to ask. Maybe you are practicing whatever faith. I will keep mentioning that. So once you've asked those nitty-gritties, always ask whether they have any particular things that they do not practice. And if they do so, then it is also good that the against medical advice forms are signed off. Again, the name, title, and signature of the person administering the consent, who tends to be a clinician or an agent acting on behalf of the hospital, the name and signature of the patient or their guardian, or a medical proxy, and you should indicate the relationship, the name and signature of the person who has witnessed the administration of this consent, and of course the date and time of consent. Anesthesia must always have separate consent, whether it is local anesthesia or general anesthesia or regional anesthesia, if you may so wish. So ensure that those things are in place. SOPs are very important. Say, for example, Veuri is a very senior practicing laparoscopic surgeon. I've been in this for 30 years, and my word is nearly low when it comes to this practice. There should be SOPs. My word is not low. They are standard operating procedures when it comes to whichever discipline of medicine. So as clinicians, ensure you practice in facilities with SOPs. As facilities, ensure you are a facility with SOPs. So you cannot tell me you got into an abdomen, for example, laparoscopically, yet your diagnosis was something like peritonitis. I mean, you will get away with it, but when it comes to the cold hard legalese of it, you are wrong. It doesn't matter how much of experience you have. At times, unless now we have and again, medicine being an evolving field, unless now there is good evidence that that what you did is now becoming a standard operating way of doing things. SOPs, they enhance communication because now you're able to tick against the checklist should that be the case, and you're able to critique my work as a physician. You're also able to critique the practices of the hospital, and that is the only way self-improvement comes. They also enhance patient safety, they improve the quality of care, and they're also important when it comes to regulatory compliance. And they also reduce risk and liability, which is a conversation we are having around now when it comes to the medical legal aspects of SOPs. We also do have what is standard, what MOH has recommended when it comes to things like pediatric care, obstetric and gynecology care, HIV, especially vertical diseases. We do have protocols on how to go about treatment of such conditions. So please adhere to protocols and document where the case is not possible. Duty of care. Again, this is something we have seen at the council come up quite frequently now. And this is where you are called as a clinician, you take some time to come. We will judge you on that. Again, we look at things at when did the duty of care crystallize. So if you're a clinician and you take a consultation, or accept a consultation, or if there's evidence of you accepting a consultation, the duty of care has crystallized. If you've accepted a referral, the duty of care has crystallized. Where you've been called in, you were just walking the corridors of the hospital, and you were told, "Theory, hebu kuja uniangalilie huyu, come and see this patient for me, throw in an eye." Duty of care has also crystallized. So it is important that even when you've been called, ensure there is some documentation to show you've been called. Even you can write on the continuation sheet of this particular patient. Again, as an aside, hospitals or facilities or clinics that are using an electronic record management system, please ensure that the byproduct of that system, if I was to ask you for those notes the moment you print them out, ensure they come out as what is considered a standard patient notes. Ensure that the system can tell us who has printed those notes, at what time they were printed. Also, it can tell us that Dr. Theuri or Dr. Bosire entered their record of this particular patient at this time, and the surgery ended at this time. So that there can be that follow-up and an improvement when it comes to quality of care for this particular patient. I've talked about the doctor-patient relationship. That's when those are the instances and many more that it crystallizes. Duty of care also ensures that the standard of care is optimal. Admitting consultants or even medical officers, interns as well, we will assess you on this. So for example, if you are the highest skill set in a facility, yet you withdrew care or denied care for reasons that are not fit in our assessment, then you have failed on duty of care as well. It should also be reasonable care. You mustn't overtreat or undertreat your patients. You also have a duty to inform your patients when things are going okay and when they are not going okay. And finally, Dr. Bosire, should you have anything to add later on, please feel free to do so. When it comes to breach of duty, I think I have clearly covered that. All right, Dr. Bosire Karibu, she's going to highlight some 3 cases here, and in doing so, we'll be able to elicit those things that we have talked about. Karibu sana, Doc. You are still muted.
Yeah, thank you. I hope it can be heard. So thanks everyone for attending this webinar. Maybe before I move on to the cases, I am going to just cover two issues that you had raised about consent. So when it comes to consent for minors, we look at it twofold. Part of it is that by the Kenyan Constitution, as further elucidated in the Children Act, children below the age of 18 do not have a right to give consent. So previously, the Act actually gave some sort of leeway with regard to what they called assent and with regard to what we call the evolving capacities of minors, which was pretty much our Kenyan terminology for maybe what we would say an emancipated minor. But unfortunately, as it stands, we do not define an emancipated minor in our constitution. And therefore, as long as they're below 18, we still need to seek consent from a guardian. So primarily, the Act assigns the parent as the primary consent giver. And what then we need to be a bit wary about, we're living in a different social construct right now. We do have families where, yes, a parent may not necessarily be the legal guardian of the child. When we look at matters to do with divorce, for instance. So as a child is brought to the hospital, one of the places where we struggle is at registration. And I think especially for hospital owners, this is very critical for you to be able to ascertain in registration, at that point, the information that is put on record is very critical. Please ensure that your registration records are clear when it comes to a minor. Who is the legal guardian? It's not just that they are a parent, but in the event that this is a family that is separated, which of the parents has been given the authority as a legal guardian to take these kinds of decisions for the child? We have had cases where one parent has sued the other for, consenting to procedures, especially things like circumcision and stuff, and has put the hospitals in a very difficult situation, trying to figure out, how this consent was obtained when the person who was giving the consent doesn't have the legal right. Secondly, we have children in emergencies. This is actually prescribed in our own guidelines, where we have adopted the international standard that in the case of emergency care, consent with the absence of the rightful consent giver, or in an incapacitated situation, or where the child's life is at risk if nothing is done. And we need to understand what an emergency situation is. So when we are talking about, for instance, things like surgery, in an emergency situation, we are talking about threat to life. We're talking about threat to loss of sight. So if a child's eyesight is at risk, then we can override consent issues. Number 3, when we are talking about loss of a limb, these have been very clearly elucidated even in the WMA. So we actually borrow from this because we haven't defined it, but currently the Medical Council is working on the Professional Code of Conduct, and these are some of the things that will be loudly elucidated in it so that we know what to quote when we are making some of these decisions. So in the case of an emergency, We want consent from two people, two professionals in the field. And if you cannot get two, because we do know that in a lot of our hospitals, you will find that maybe there's only one, let's say pediatric surgeon, and this child needs to go in, then the other party who gives consent then can be the medical superintendent or the medical director of the hospital. Please note that if you're the one going to operate on this child, you cannot be one of the signatories for the child's consent, or even for an adult in the event of an emergency. Now, away from parents, when the legal parent is not available, the Children Act actually gives the next level person given the responsibility is the children's officer. And beyond that, then we move on to the courts. Now, unfortunately, despite the fact that the Act spelled this out, it did not capacitate our children's officers to be present in our hospitals. We do know that they exist. A lot of facilities actually do not realize that these people have this capacity to support you, or in the event where we have a parent's decision is putting the child's life at threat. So we are usually expected to call on the courts to do for us. And the court processes can be very long. But every sub-county facility, every sub-county in any county has a children's office. And as a hospital, those people are supposed to be on your speed dial. So when you have moments at night, moments on the weekend, you're actually supposed to be able to call upon a children's officer on call, and they can actually guide and facilitate the necessary consent. Now, beyond there, the other thing I wanted to talk about consent is to remember that a patient is allowed to withdraw consent, and their withdrawal may not be complete, it may be partial. So some of the things that Dr. Theory was highlighting, that when you talk about, for instance, for religious belief, somebody says that they do not want a blood transfusion, what we have struggled with is people not understanding then what. So the law basically dictates that you're supposed to provide the highest attainable standard of care within the confines of the consent that the patient has given you. So if they tell you no transfusion, your job is to make sure that you give the best possible care within the space of no transfusion. So you cannot turn the patient away or say that because you have refused to comply or you have refused to give full consent, then my work here is done. That again would be, neglecting your duty of care. The other things that we need to remember to ask consent about, especially hospitals, when you prepare your consent forms, please remember to consent to disposal of body parts. We take it for granted. Your patient has had an amputation and you just discard their leg and you didn't ask permission. There are people who want to bury their leg. So please make sure that it is expressly consented to, and where they may not be able to take the body part home because it needs to go for histological analysis, let's have that conversation upfront and dictate, because sometimes they can allow it to go to the lab, let the histological specimens be collected, and they can still collect their body part and take it home. Then we are trying to move away from terminologies called against medical advice, unless it is really a patient absolutely refusing, because we're saying allowing consent with the following reservations. It is a more politically correct and more formal engagement, because we do not want to make it look like we are pitting ourselves against our patients. And then that means that we are looking at them as what I call difficult patients. But my definition is that there is no such thing as a difficult patient. There's only a patient in very difficult circumstances. We need to figure it out around them. Also remember that sometimes your patient may need a translator. So as we're having a witness, we also need to have the translator sign that this is what they have explained to the patient, translated it as the doctor has put it, and then they put it on record. This is something that countries like India have done very well. They actually record the consent process on video, because that is how litigious the world can get. So in the event, sometimes you feel like you're in difficult situations, as a hospital, you can actually avail video recording service, get consent to do the same, document the consenting process, and especially for those now who are going digital in HMIS, you can actually upload that onto the patient file as part of medical records. Finally, my last comment on duty of care is small facilities that are private. We're struggling with when you have a level 3B maternity unit, you are delivering babies, you are working with medical officers, and all that is within the confines of the classification of the facility. Unfortunately, when we come to emergencies, it becomes your consultant is deemed to be on call. Now, having a consultant on call is not a problem. The problem is the manner in which these consultants are engaged. It's for a lot of facilities, it's very ad hoc in a manner that does not actually make the consultant have any duty of care. So if you're going to say, this is going to be the consultant I am going to be relying on in case of emergencies, certain things must come into play. A consultant cannot walk into theater, bail you out for a PPH, do a hysterectomy, and postoperatively disappear. Literally their involvement with the patient ends on the operating table. That is a problem. And a lot of facilities will do this because they cannot afford to sustain these consultants. If you don't think you can, please refer the patient. Please refer the patient. Do not do a procedure. Your consultant is never coming to review this patient. The patient is now being managed by, if you felt the need to call this specialist to come and assist during some point of care of this patient, they need to see it through. So we expect post-operative follow-ups. We are also struggling with when you give them admitting rights or you invite them to see your specialized patients. You have an orthopedic surgeon who comes, sits in your orthopedic clinic, sees 3-4 patients, books them to surgery, comes on Thursday, operates all 4 patients and disappears. They don't see this patient post-op. They do not follow up. The patient is then passed on to the clinical officers and discharged in accordance to the clinical officers. This patient started care at specialist level. They had surgery at specialist level. Their post-operative care all the way to post-operative reviews is expected to be under specialist care. So the story of the patient is being taken care of remotely that we reviewed, we called, the consultant said is fine. That is neglect of duty of care. And once these matters come before the council, we hold both the hospital to account and the individual consultant to account. So if this isn't something that your facility has been practicing, kindly ensure that you enforce this so that it is properly covered for the space for duty of care. So moving on to the sample cases. These are some of the cases that have actually come before the medical council in the recent past. And they are just, being picked out for lessons learned. So Maria, a 61-year-old para 4+0, 10 years postmenopausal female, presents to the clinic where she's seen by an OBS-GYN. Her complaints were vaginal bleeding on and off for about 6 months, which progressed to bleeding like throughout the whole of the previous month. She was known to be hypertensive on antihypertensives for more than 10 years, and she was also obese. She was known for heavy alcohol consumption. She had no history of smoking. She did have a family history of diabetes and hypertension. So on examination, her abdomen was distended. It was pendulous with no palpable masses, no areas of tenderness. The pelvic ultrasound done showed a bulky uterus suggestive of uterine fibroids. Routine blood and urine tests were done, and there were no other additional investigations. So following these findings, she was planned for admission for a hysterectomy plus bilateral salpingo-oophorectomy due to symptomatic uterine fibroids. A month later, Maria is admitted at a tertiary level hospital for surgery. She's reviewed by the physician and is confirmed to be fit for surgery. Consent is administered and signed in front of her husband. So intraoperatively, the same OBS-GYN who scheduled the surgery from the clinic performs the hysterectomy, and there was no peritoneal or lymph node sampling. The excised uterus is sent to the lab for pathological examination, and results are expected in about 10 to 14 days. Now, the patient was neither informed of this waiting period, neither was she told to follow up with her results. So on the 4th post-op day, she's discharged and she's scheduled to be reviewed in the clinic 2 weeks after. So a week later, she returns to the same hospital where she had surgery because of wound sepsis. Now, the gynecologist who was on duty and operated on her the previous week is not on duty now and is somebody else, who is the one who reviews her, admits this patient under the surgical team. There are multiple reviews by this second OBS-GYN, despite the fact that the patient is now really fully under the care of surgeons. The wound sepsis was managed and the patient eventually went home after about 3 weeks. So 6 months later, Maria is rushed directly to the same hospital in critical condition. She has been attending her regular clinics for follow-up for hypertension at the clinic where she's seen normally, and during this whole period. The histopathology results, which have been in the hospital file since the second admission, they were filed, but they were never reviewed, are now being seen for the first time. When Maria is coming in with this, everybody is trying to figure out what's wrong with her and what's making her so sick. So at this time, this is the first time these results that were now looking back, we're talking about more than 6 months, are being reviewed, and they actually demonstrate that she had stage 2 endometrial carcinoma back then. So, investigations now carried out during this admission revealed she already had stage 4 carcinoma, because now there was metastasis all the way, including to her lungs. Her condition deteriorated and she died about 6 weeks later. So on lodging this complaint, the complainant, the spouse, actually complained of failure to inform the patient that she had a terminal illness, hence the delay in commencement of treatment, which resulted in premature death. So you can see with the matter that we're raising here, what are the issues that were noted in the healthcare given to Maria, and how are we able to learn from this? So first of all, we're talking about the issues of duty of care, which I think Dr. Theory has really gone through. But even before we get to the actual intervention, our conversation started from diagnosis, where we actually are skipping the standard operating procedures as expected. Now, as we discussed, a lot of the SOPs will be laid out by the Ministry of Health. We expect institutions to actually take this, customize, and adopt for function. Now, not all of the medical cases we have or surgical cases we have can have standard operating procedures. But where things go south, we actually fall back to what are the international standards of care when we do not have local. And also at professional level, evidence, what is it saying? What is the latest care that is provided for? So for this particular patient, care started from a missed diagnosis. Postmenopausal, 10 years down the line, vaginal bleeding is always endometrial cancer until proven otherwise. This patient should never have gone for surgery without an endometrial biopsy, whether it's done, under anesthesia or it's done as an office procedure, to first ascertain diagnosis before the patient goes in for treatment surgery now. So crucial investigations were missed. Crucial information was therefore not dispatched to this patient. As she went in for surgery, she had no idea that she's going in for treatment of cancer. Communication was a problem. When this patient was readmitted, there was no handover between the two teams. But even worse is that the second gynecologist, having noted that you're receiving a patient who had surgery last week with a different team member, did not even reach out to find out what's going on, or even to report that, oh, your patient is back and this is a situation. There was no communication about handover of results. There was no noting that there were pending results that were supposed to be followed up. There was no explanation as to where were these results supposed to have been accessed and given back to the patient. Was it going to be coming back to the hospital of surgery? Was it going to be at the outpatient clinic where she has been on follow-up? And then there was now the lack of patient follow-up overall post-operatively, because if she was scheduled to come for review 2 weeks down the line, she has not come. The doctor who was supposed to have seen her has not made any effort to find out why the patient did not arrive at the clinic. She had no way of knowing that this patient has been admitted into the ward. So that patient follow-up was lost, and this cost the patient dearly. So again, because of not having upfront diagnosis, this patient did not benefit from initial care with the highest attainable standard of care when we're looking at the highest attainable skill set for the management of this patient. This is a patient who could have easily accessed a gynecological oncologist to perform the initial surgery from the outset correctly, simply because 1, they could access this person, and 2, they could afford this person. Next. So case number 2, we have Fatuma, a 62-year-old para 4+0 again, postmenopausal female. She's seen by a resident family physician at a private level 3 hospital in Nairobi. She also comes with bleeding for the past year. A pelvic ultrasound suggests a suspicious endometrial lesion. A full mammogram and a random blood sugar. A random blood sugar were actually done and they were found to be normal. There were no additional investigations, and the pap smear done 6 months earlier, which was negative, was relied on for decision making. She was admitted for the TAH and bilateral salpingo-oophorectomy, and this was performed by a family physician. There were scanty non-descriptive surgical notes for this patient, and she was discharged on her 3rd post-operative day. The sample was sent to the pathologist 24 days after the fact. So the specimen was eventually reported to be endometrioid carcinoma with squamous differentiation, FIGO grade 3. Next. So there was no evidence of post-discharge follow-up for this patient because the file availed was the hospital file. There was no availing of clinic records to show what the laid out procedure for this patient was and the care even after discharge. So 2 years later, Fatuma is brought back to the same level 3 hospital in critical condition. A review at the outpatient department notices that she's a very sick patient who required immediate referral to the national hospital in an ambulance. She actually was pronounced dead on arrival. So the complainants who lodged this complaint they complained about failure to inform the patient that she had cancer and to refer her for further management, which ended up resulting in metastasis that resulted in a premature death. So again, the issues that arise out of this, as you can see, the similarity from the previous one. First and foremost, scope of practice. Scope of practice is going to kill us. KMPDC actually should be launching the finalized scope of practice that is very descriptive of what care practitioners can do within their scope. It's going to become very punitive now because there's a reference point for anybody who treats patients beyond their scope of practice. Secondly, the Nursing Council has had a fantastic scope of practice for many years. And that's why you find a lot of nurses are very clear about what they will and will not do. So even as, hospital administrators, managers, and owners, you have to respect that. Like, don't push the person you have employed to do what is beyond their scope of practice, because ultimately, when things go south, it will be, again, a shared responsibility for failure. Patient follow-up is critical. It needs to be communicated. Even our discharge summaries indicate when is the patient being reviewed, what is the date, what is the time, what is the place, so that then it is clear that the patient was communicated to where they were supposed to go. Then communication with patients, particularly for this patient because she was deceased, one of the defenses that the practitioner was trying to put up is that as far as is concerned, he told the patient about her condition, and she's the one who declined further care, and she's the one who declined that he tells her family. However, he could not demonstrate that because he did not have any documentation whatsoever or where this conversation may have happened and how it was agreed upon. So yes, there are times when patients can actually exercise their right to refuse to share information. They can exercise their right to treatment by opting out of active treatment and opting to, sit it out, and that's okay. What we need is proper documentation. Now, part of the things that then we are encouraging is why we have really pushed for things called the family conference. Did this patient walk into hospital alone? No, she didn't. When she's here, even before we go in for surgery and all that, forget the fact that because there was no scope of practice, there was failure to appreciate that this patient at 62 with bleeding was likely having endometrial cancer. The challenge is that there was also, the patient sort of was isolated in care from the outset. There was no request for a support system or then being able to document that she's the one who has declined a support system. And when we do family conferences, kindly let us document. Document who was present in the family conference. Document, literally, if you have to do it verbatim, please do. Document what was discussed. Document the concerns that the family raised and how they were addressed. Put all this in writing and have a representative of the family sign, so that they do not wake up and say they claim they held a family conference as we were not told, as we did not know. And also have hospital representation do the same. Next slide. So Sultana, a 35-year-old para 2+0 single mom, presents to a public level 4 hospital with heavy menstrual bleeding. She's had a previous cesarean section. She's not known to have any comorbidities. On exam, she has a slightly enlarged uterus. The pelvic ultrasound showed uterine fibroids. Hemogram and urinalysis were normal, and she was advised on management options and opted for a hysterectomy. Now, because of where we have been with issues of workload in the public sector, her surgery kept being postponed for a whole year. Eventually, one of the gynecologists at the unit advised her that she can have this procedure done at a private hospital where he will be able to do it at a fee separate from the hospital fees. Next. So she proceeded to the private hospital with the doctor's note. Please note that this conversation happened in the morning, and by afternoon, Sultana was being admitted in a private facility. She was admitted for hysterectomy that very afternoon. She consented, the consent was administered by the OBGYN. This surgery was, the hemogram and urinalysis were normal. There was no new imaging done, despite the fact that it had been a whole year since the previous one. So intraoperatively, there were no fibroids noted. There was a solitary tumor on the left ovary, and it was noted to be adherent to the retroperitoneum. She had a cystic right ovary. Both hysterectomy and bilateral salpingo-oophorectomy were done. So the next day, the doctor informs the patient that both her ovaries were removed because they had a problem. The patient is adamant that she did not give consent for removal of her ovaries. Please note that she's 35 years old. Further, the OBGYN asks for additional fees in cash so that they can send this specimen for histopathology to be done at a private lab of his choice. So the patient is discharged and she's scheduled for a follow-up visit 2 weeks down the line at the doctor's private practice. So at the review clinic, the doctor was unavailable when Sultana went there. She decided to go back to the public hospital where she had first met him, and he reviewed her there and he sent her to check for the results at a private hospital where he performed the surgery. The hospital says it has no record of any tissue sample sent for testing in her name. Because the hospital did not have in-house capacity to carry out histology, the specimen had to have been taken elsewhere. So she informs the OBGYN, who promises to find the results and give them to her. She followed this doctor for over a year. She never got her results. She never got any communication. She never got any feedback. So she actually lodged a complaint complaining about the doctor removing her ovaries without consent and without her knowledge. Again, as we can see, the issues that are arising out of this are quite multiple. They also heavily put the character of the said doctor in question, especially with regard to professional conduct. Okay, so what were the issues noted? First, there was the issue of misdiagnosis. Again, have we had issues of misdiagnosis because of wrong imaging? Yes, we do. However, you have to have demonstrated that the correct imaging was done at the correct timing to be able to say that, yes, this misdiagnosis really is not as a result of the practitioner in question, but maybe the imaging person. And this also brings a lot of questions with what is the skill set of the people that we hire in our imaging departments, because we have really had a lot of issues from this particular area. Number 2 is informed consent. Again, I think Dr. Theori talked about this, where within the space of requesting for informed consent, one of the things you must clearly request for is consent for additional procedures that may be necessary to either save life, to avert a complication, or to reduce morbidity. So it doesn't make sense to go in to remove fibroids and find a patient has an ovarian cyst, and then because you didn't have consent for an ovarian cyst, you close, and then you come again and subject the patient second time round to anesthesia and the dangers of being in theater to now remove this cyst. Now, within that space, where unanticipated events are found, do you have the skill set necessary. So if you are a general gynecologist, and you go into an abdomen and you are anticipating fibroids, and you go and find that this looks like a sarcoma, are you qualified to actually perform surgery for sarcoma? Are you in a position to get the gynecologic oncologist on the table with you? If you are not, then you are actually better off closing this patient, reversing this patient, discussing this condition, because you will have had an opportunity to take a biopsy, await results, and then reschedule this patient properly for the surgery that they require. We have to be honest enough to tell the patient, we had no option but to reverse you and redo this again, because we do not have either the correct facilities in this institution to support this procedure, or we do not have the sufficient skill set to address this problem. Patient follow-up is critical. You owe it to the patient. Duty of care is not over because the patient has been discharged. They have a right. They started with you as a private doctor, they will continue. They started with you as the hospital of choice. You owe it to them to continue the follow-up. Again, billing of services needs to be transparent, because this puts into question a lot of our moral authority as practitioners to be seen as, not fraudulent. So this is necessary to be very clear that the patient should know from the outset, you're going to have surgery. I may not like the hospital's lab. I may prefer for the specimen to be taken elsewhere. Kindly collect the specimen, advise the patient, write your request form, and let them deliver. If you're okay going through the hospital, kindly ensure that if it is calling for additional costing, especially in hospitals where packages are required and they do not accommodate the further diagnosis, the patient should be informed upfront prior to surgery that there'll be an additional cost, and the cost is this amount, and it is going to be for this particular reason. And make sure that those results are given back and followed through so that they also understand what were they paying for, and they must be part of the decision-making process. And then, of course, the third delay, where we are struggling with delays over a whole year for patients queuing up, waiting to access surgeries. Now, the upside of this is, of course, what has happened over the last few years with NHIF, because it brought on board a lot more providers and patients had a lot more options for where to seek care. We have really drastically reduced the waiting times in our public facilities. However, it is then going to make it a lot harder for facilities to justify why patients would be waiting for life-saving surgery for, unexplained durations of time. Next slide. Good. So we'll discuss a little bit about professional indemnity. And I know everybody was very unhappy when we said you must take professional indemnity. Now I'm even more upset that people have professional indemnity and they do not understand what it is supposed to be for. So professional indemnity is, of course, a liability insurance that provides financial protection from a professional. Keynote, it is specifically a professional from bearing the full cost of defending against a claim made by a client about their work. So we have to actually understand that when PIs were first introduced, they were actually intended for legal practices. The medical professional indemnity was much an afterthought, and that's why most insurance companies still have not crafted their agreements in a manner that speaks to the medical language. And we do have to really read in between the lines before you decide who are you taking on as your professional indemnity provider. So we do have hospital malpractice insurance now for health facilities, which protects the facilities from bearing the full cost of defending against a claim made against a client. Now, this had to be enshrined in the law for it to be enforceable, that every practitioner shall take a PI every year, and every health institution shall in each year insure the institution against professional liability of its staff. Now, just because the hospital you work in has a health institution cover does not cover you as a professional. The reason for this is that when complaints are lodged, there is a clear separation between hospital and professional. And as a professional, you will be sued in your own capacity, even when you are employed as a full-time employee of your health facility. And the health facility will be sued independently, even when it was a private practitioner with admitting rights who admits a patient in the institution. So there's a clear separation of these two roles and responsibilities, and is the reason why everyone needs to be insured independently. So of course, the insurance companies will issue this and they have to be certified by the IRA, and the terms are negotiated with the provider. And everyone, please read your policy document. You need to know what your policy document is covering you. It should detail your limits. What are you covered? How much? What is the scope of practice covered? You'll be surprised that some of them may tell you, oh, we'll only cover you if you're in high court, which means that your initial entry into litigation, which will always start from either KMPDC or a magistrate's court, they will actually not cover. So we need to be very clear about those details. You need to know who it covers, especially for hospital malpractice covers. You need to understand, because they will count down all of the practitioners. You have to be able to effectively calculate your risk profile before they tell you how much you're due to pay. So you have to be very clear who they are covering, because a lot of people only sign up the doctors and the nurses and what have you, and they forget people like lab or the imaging department, and this become a liability. Then of course, the legal and defense costs that they will cover. Are they providing their own own lawyers? Are they allowing you to use your lawyer at their cost? There's the defense costs, but there's also the bit for, will they pay for the costs of the rulings that arise out of that? Then what are the exclusions? Are you going to pay any excesses? And for what duration are you covered? Next. So yes, one of the things we always say is that a patient, even you as a practitioner, can be a patient. You have a right to complain about any aspect of the healthcare service you receive. We always say being sued is never been a problem. It's never gonna be a problem. We're never gonna stop being sued. What matters is being found culpable. So a patient has a right to complain, and they can complain about anything. Most medical legal complaints will arise from the patient or their family, their loved ones, perception of the standard of healthcare given. So remember, not everybody has a similar perception of standard of care. What my standard of care perception will be very different from somebody else's. So what I might think is a problem might not be a problem to somebody else. That also includes how you, the provider, perceives quality of care. Then whenever there are any queries, please respond truthfully, respond promptly, and make the limits of one knowledge very clear. Now, one of the challenges we have is that we have to always remember that the complainants are extremely emotional when they are complaining against you. So they can be rude, they can be mean, they can really put emphasis on things you cannot even begin to understand. However, what we ask is that when you are responding, do not respond to the emotion. Your response has given you an opportunity to detail in a stepwise fashion from the initial point of contact with this patient to the end, what it is you did, what it is you didn't do. So go back to your file and respond professionally. I saw patient XYZ on this date. This was our interaction. This was the findings, history, findings on examination. This was the investigation. This was a conversation about treatment options. This is what the patient chose. This is what we did. Please put dates. Please put times. They actually help to give a clearer picture of exactly what happened on the ground. Do not respond to the emotions. Do not respond to the patient says they did not even care. They left me to lie there in a pool of blood. Please just focus on saying, this is what we did. This is what happened. Next is professional indemnity, and the hospital malpractice insurance covers will always protect you. Now, I am struggling with seeing medical officers, let me speak to medical officers in particular, who are employed by hospitals, who find themselves sued as an individual separate from the hospital. And then you show up at KMPDC represented by the hospital lawyer. Please stop that. You have been sued as an independent entity. Your PI covers for your lawyer as an independent, for yourself and your lawyer as an independent entity. Procure your own lawyer, please. Just this last quarter, we had a sitting. It happened twice. 2 medical officers coming in. They're represented by the hospital lawyer, who is not only representing the practitioner, but is also representing the hospital. And what they don't realize is that the hospital is going to throw you under the bus. It doesn't matter how long you have worked for that hospital, how committed and dedicated you have been. Bottom line is that whatever they can do, that is what lawyers do. The hospital may not be throwing you under the bus, their lawyer will, because their lawyer is here to win a case for the hospital. So come with your own lawyer, let the hospital come with their own representation. It is why we are forcing you to take a PI. Its job is to pay for your lawyer to represent you. So whatever you do, clear separation, please. Say this to every other practitioner, you know, clinical officers, nurses, you all take PI now. Please invoke your PI to cover you. Do not be caught up that because you're a hospital employee that the hospital will cover you. It will not. Thank you.
I think you agree with me, Nelly has done that justice. We have a few questions, Nelly, and I will also roll over to some of the things you have said. And one is the issue of indemnity. Please also ensure that as you're picking your cover, the duration of your PI is clearly indicated. So for instance, a case, and what we find is that most of these cases tend to be a year or so late. So ensure that there's some form of coverage for prior duration of practice on these PIs. Also, you may want to include a clause for negotiations, covering of mediation fees during should that be an option that you take. Some insurances or rather underwriters will also give you the option of entering into negotiations first before you even come to KMPDC. Please note, because of the rigorous nature of the process at KMPDC, 98% of my rulings are upheld from the committee at the High Court and also at the Court of Appeal. So it's important to know that the High Court and the Court of Appeal generally tend to rely a lot on what KMPDC has said. Nelly, I have a few questions. First is on disposal of body parts, like you mentioned. Placenta, where does this fall in? Is the first one. And the second one is, at times, patient will come and say, I want a report of what happened to me during the time you cared for me or my relative was being cared for. Does that amount to a medical report that you should charge?
Okay, so placenta is a body part. I know we have routinely made a practice of not asking what to do about it. Please, you know, nowadays people even want to eat their placentas. So, I mean, I think these are some of the questions. For me, what I have done in practice, I have the privilege of being in private practice, and therefore, because I serve a smaller proportion of patients and repeatedly see the same ones, there's a lot of camaraderie that develops. But part of birth preparedness, one of the things I have actually learned to tell them is to actually mention this placenta business. And yes, people, we not normally explain to them what we do with the placenta. And normally that then gives them an option to ask questions about it. And of course, they'll make fun of it. Generally, I've never seen anybody who wants to take their placenta home, but don't assume. I also do serve sometimes very interesting foreigners who come with very interesting ideas. They have read on the internet. I remember there's one who brought in something that I had never seen, and she was asking whether her baby can be delivered and go home with their placenta still attached. Apparently, it's an in vogue practice right now. So apparently you clamp the placenta, the umbilical cord, but you do not cut it. And so once the placenta is delivered, it is put in a bag and it's attached to the baby until it falls off. Don't ask, but yes, that's happening. So one of the things then we have to do is, let's normalize having this conversation so that patients feel like this matter was talked about and I did not indicate differently. But when we do other body parts, I think it's and that's why I say just put it in the consent. Because once the patient reads through, it also forces you to remember to mention it to the patient at the point of signing consent. The other one was the medical reports. As per the KMPDC fees guidelines as they exist now, and we are actually working with 2016 guidelines, a medical report is actually a chargeable service. So you should have no fear of putting it amongst your documented costs of procedures, writing two things that most people don't realize: medical report and testifying in court. So if you are invited to testify in court, you are actually eligible to charge for that service. So do the medical report make it as exhaustive as it was without having to give the patient a file and give it to them. And in some instances, there are actually practitioners who have normalized doing that every time they see a patient for the first time and they do an overall screening, or where their patient is referred to them for review, they will actually do a medical report, give the patient a copy, and send one to the doctor who referred. It's practice that we have to sort of embrace moving forward, because it's becoming international best practice.
All right, thank you. Now I'll come to the Q&A section. We see what you can pick from there. I will endeavor to possibly end within the next 10 minutes so that we keep the promise of being within the 2-hour period window. We will share, Laura, Lema, we will share the slides. They should be on the KHF website. So Martin, ensure that the recording of this webinar is on the KHF website. Dr. Sadia, a case has been lodged at KMPDC since that's 2012. 2023, so I don't think 2022, 2023. The lawyers have written to the board. We failed to respond or acknowledge or provide an update. What should the family do, and advise how long such cases within the board and the legal system take. We have a backlog indeed at the KMPDC, with most of my cases being between the year 2020, a few in 2021, 22, and now 23. And we are trying our best to clear these cases. We are now sitting at least twice quarterly for 2 full weeks to try and clear this backlog. We have engaged external counsel so that we are able to deliver our rulings within at least 60 days of our hearings. So is mainly a resource constraint on our end, and also to do with the expertise internally. However, over the last 6 months, we've tried to do away with most of the cases as we can. We've also gone a second step further, and we are going to reprimand facilities and clinicians who withhold documents that we've requested for, that will enable us in delivering some of these rulings and hearings, because at times it's impossible to take some decisions without some form of the documentation that we've requested for. So you will see movement, especially around the reprimand section of my statement, so that we ensure justice to our countrymen is done. The second question that Dr. Sadia had was a nephrologist has taken care of a plastic anemia and refused to hand over the patient to an oncohematologist. The family requested for a second opinion, and he denied after depleting the resources. The insurance cover rather to up to a tune of close to 2 million. He discharged and demand 500,000 before release. What should the family of the patient be advised to do? So one, a doctor cannot refuse to hand over a patient. It still remains the patient's right on where they can seek care. If you have been admitted and you've sought maybe a discharge, then it can be a discharge following with the following conditions, as Dr. Bosire has rightly said. This patient, or rather this family, can easily report to KMPDC, cite the doctor or the facility as the respondents, and we are going to pick it up. It seems pretty straightforward to me. If there is evidence of any inappropriate conduct by the clinician, then action will be taken against them. If there was none, then we also do have family conferences at KMPDC level, explaining to families and complainants on our thought process building up to where we say that maybe there was no culpability. Dr. Malenya says that the quality of informed consent is a major issue in our communities, and what is being done in our setting from a regulatory point of view to ensure that consent, that the consent given is of acceptable quality. I agree with you, Doc, and what we have done is we have a guideline. I will show it at some point when we are ending the conversation here on what the tenets of a good consent form should be. Doc, you're a dentist. Some of the things I will highlight, we do give local anesthesia And you should have consent for that, even where multiple procedures are anticipated within the same treatment regime for this particular patient. Let your consent form have that, and where you deem nothing has changed in the initial assessment of your patient for the subsequent treatment, just have somewhere where you tick or sign against together with your patient, informing them of that. The second thing is we will have a population that is highly sensitized to insurance uptake, meaning the health-seeking behavior is going to change, of course, with the introduction of SHA. So we need to ensure that also your consent has a financial section where if the patient, if your practice is that the patient undertakes full responsibility to pay, that they sign that. Where there is co-payment, it should also include that failure by that person to pay or by that entity to pay, maybe within 6 months or 3 months, as you shall decide, then the patient undertakes to pay fully. And that in the process of recovering that debt, it is important to include some patient information may be disclosed. We had a case where a clinician sued a patient for failing to pay their bill, and then the complaint went to the High Court, and of course we were roped in, and the patient countersued and said, you have disclosed pertinent medical information. So where does that leave things? So it becomes a very difficult case to adjudicate, and whereas you had a very strong position initially, it can become watered down by such counter suits. The other thing is, so I've mentioned on payment, the obligation of payment as well. So I will take that as answered. Martha Whitty, we have a 17-year-old currently. We have 17-year-olds currently in universities, away from their parents and guardians. Do we still have to seek consent from parents, e.g., for blood transfusion and conducting basic blood tests? Nelly, please assist with that.
Okay, first, those two things are very separate. In fact, right now, what institutions have begun to do is that they have actually developed a blood transfusion consent form that is independent of all other consent forms. Now, there's no 17-year-old who was not registered in college with a proper documentation when they're a foreigner on how to handle these matters of consent. So if you're attending to students from university, maybe what you need to do as a facility is improve on your communication with the facility so that, and remember what I said, a lot is always hinged on at registration. People really take it for granted, and a lot of the times we do not train our health records officers on issues of registration. So a patient is brought into the hospital, and there's all this information field there, and there's who is the next of kin. Now, a lot of people really downplay the importance of next of kin, especially when we're talking about these 17-year-olds who come to hospital accompanied by their friends. And then the next of kin is their fellow 17-year-old because that's their friend and classmate who brought them in. That's where, as a facility, we must start to strengthen. You've come in as a patient. You need to be treated. Who is your next of kin? That must be correctly documented. Now, for basic blood tests, you'll find that, as I said again, assent may be fine. But when we come to things like blood transfusion, things that could actually result in complications that were unforeseen, you need consent. Things that could have alternative treatments. You're transfusing. Is there an alternative to transfusion? We know there is. It may not be the most suitable alternative at that time, but it's an alternative. So you do need valid consent. And this consent has to be given by a person who has authority to actually do this transfusion. So some of this consent may be given verbally and must therefore be documented that parent XYZ called at this time. Please document the time and the date for purposes of authenticity, consulted about their child who is here for treatment. This is what they say they require, and they gave consent verbally. And have a witness sign against you. It will serve as consent in physical absence of the person, even as you wait for that to be reinforced by final written consent later. That would be important. Then I see the next question is also asking about the same use of electronic and digital signatures in practice. With the coming of HMIS, yes, they are actually going to be acceptable. What we need is what digital signatures are we talking about? Because what I have seen in facilities that have gone digital is that they usually have a tablet, and the patient then reads the consent there and signs on the tablet, and it's uploaded into their medical records. That is fine and it's legal because it is reproducible even in a court of law. The timestamp is there and it cannot be refuted that it was not signed by the patient. However, if that is the level of consent we're talking about, that should be legally acceptable to the institution too. Mm-hmm.
All right, thank you. The next question is use of electronic signatures. You mentioned that. State that even with local anesthesia, an anesthetist should guide. Should you get consent? The answer is yes. And what of a situation where the doctor or surgeon is using a leg, like to remove a lipoma, have separate consent for the anesthesia bit? What kind of anesthesia you're using, when it will be, where it will be administered, potential side effects, and what are your plans of mitigating those side effects? Have separate one for anesthesia, even where the operating or the performing surgeon is the one who's administering it.
Allow me to add on that.
Yeah.
I think a lot of people really downplay the complications that can arise out of local anesthesia. We have an upcoming matter in the Medical Council where a patient died out of local anesthesia, and we have to deal with that. Please do not think that local anesthesia is minor. Okay? Local anesthesia is a drug, and the patients can actually have adverse reactions. They can have an anaphylactic reactions that can actually die out of those. Being in a public hospital is not an excuse not to seek consent. At the point at which issues of consent are discussed, it will not matter whether the hospital is public, private, whatever. It will not matter who the person administering the service is. We know that most of our family planning clinics are actually run by nurse midwives, and sometimes the clinical officers in reproductive health. Please make it a habit. If your institution does not have a consent form for the family planning clinic, please get one. That JADEL you're removing, even to put it, requires consent. Just because a patient chose it does not mean that they do not need to know the potential complications that they could arise out of that. So we need to regularize or normalize having consent for literally everything we do, because that is actually the basic standard of care.
All right, awesome. We continue. The other one is what happens in situations where a patient is not satisfied with the intervention and reports to the council, and then before the case is determined, returns to want to be seen by the same doctor. Interesting case. Doctors or clinicians also have rights as well, where you feel as a clinician you're not comfortable proceeding with seeing this patient. Please document your reasons and refer appropriately to a clinician of similar expertise, if not higher. So this does happen, and we don't expect all your patients to be satisfied. However, we expect you to give reasonable care and to practice a duty of care to as best as is possible given the situation you find yourself in. Remember to always document. It is not always where, it is just a matter of time if you are practicing that a situation goes wrong. It's a matter of when, not if. Same way, if you follow a policeman for 100 kilometers, they'll also pick a traffic offense. So the same case for ourselves. We shall send the webinar as well and the slides. Let me tick them off. The other one is by Madeline CS, where the anesthesia is spinal, and intra-op you decide to do a BTL. So do you just beep and ask the patient to endelea? And they say yes. Does that form valid consent, Nelly?
No, it doesn't. That is a very coercive space.
Yes.
That is the reason why consent is done away from actual theater and actual surgery. The procedure, and that's why I talked about additional procedures. At the point where surgery was being discussed, these are the things that should have come up. Would you like a BTL? It's actually part of antenatal care. You're supposed to discuss this as part of antenatal care so that by the time the patient is now coming to surgery, then she can be able to say that. We've had very interesting cases where a patient says, oh, if it is a boy, then you can do a BTL. If it is not a boy, then don't. That is not consent. So the patient has to be very clear before they are actually under anesthesia. Are we having BTL done or are we having BTL not done? And that is, so even if she's under spinal and she cannot force you, because the consent is there to protect you as the doctor. So you cannot give up your protections at the whim of the patient who is on the table just because she's awake. Being under spinal doesn't give her a less coercive environment to change her decision.
All right. We should comment on a phone call consultation and duty of care thereafter. I think this is quite easy. The moment you pick that phone call and you engage in a manner that is a consultation, the duty of care is crystallized. My advice is that first begin by a disclaimer, especially when you've not done a full examination, that has not been done. But more importantly, it is good to do what corporate people do. Following our phone conversation, so you list the things you discussed and give any disclaimers should you have any, because in the era we live with the scarce human resource, some of these things are pretty much inevitable. Also in the course of your work, there are patients who you become close with and these things happen. So follow with the text so that at least there is full understanding of what has just happened. What do you recommend a suitable cover for medical officers, Nelly?
I frankly don't think there's any such thing as suitable
Yeah.
because things are different and patients are different. And unfortunately at KMPDC, the actual heavy burden that comes out of an engagement in the litigation process is usually the awards. Now, if a patient, for instance, has suffered, you're found culpable and the patient says, I've suffered this loss, and the award is set at 20 million. Usually the award is always more costly than the legal fees. So you have to remember that when you're taking a cover, you're protecting yourself against the award. That's usually the bigger problem. Our courts have already set precedents. So in law in Kenya, as long as precedence has been set, the subsequent court can always quote back on that precedence and use it as a yardstick. Our current precedence for awards in court stands at 56 million awarded to one of our private hospitals, and they actually have to pay the client. Now, for the issue is that people assume that because you are a junior doctor, that your award is likely to be less because you are junior. That's the thing insurance doesn't tell you the truth about. When you're being awarded, when somebody is being, the court is awarding damages, they are not going to be taking into consideration your level of practice. They are going to be taking into consideration the damage that the complainant has suffered. Now, at KMPDC, we do not set the standard, we do not do the awarding of the fines that the person, KMPDC only fines you. And what KMPDC fines you, you pay to KMPDC. It is to offset the cost of this committee having to sit here and hear the matter when you're found culpable. Now, for damages, we actually expect you to negotiate with the complainant. And once you have agreed, we have negotiated, this is how much we have agreed to pay, this is the payment plan, then we actually record that as part of the ruling. Now, if you refuse to agree, then this complainant has the right to take the ruling from KMPDC and sue you in a civil court of law, and the court of law will then determine the damages because you have failed to agree at negotiation level. I promise you, you want to agree, because generally the courts have been a lot more punitive than even most patients think to bargain for from the outset. So where possible, try and agree, and don't let your insurance arm twist you. You actually paid for a PI for them to pay out. So yes, they sit in the negotiations. A lot of the times they'll be the ones haggling because this is their money. But generally, if the award is higher than your PI, you are going to settle the difference out of pocket. So for medical officers, don't ever look at it from the perspective of because I am junior, my award should be less, that I can't be compared to the neurosurgeon. The neurosurgeon may have damaged a nerve in the finger and they will be told to pay 5 million. You may have done a cesarean section wrongly and we had a mother who died because of PPH because you forgot to ligate a vessel and she has 6 kids at home and the husband will sue you for raising 6 children by himself without a partner. And the award can be 50 million. So it's never, there is no such thing as an MO versus a consultant. That's how the insurance classifies it. But for yourself, try and aim for as much as you possibly can. If possible, try and keep it above 20 million at the bare minimum, if you can.
All right, thank you. There's a question on telemedicine. How do you handle duty of care since it's not always possible to reach patients on phone for follow-up? 2 things here. One is telemedicine practitioners are first registered as a level 2B facility physically. So remember that. But more importantly, as you're beginning so there are also 2 ways of engaging your clients. There are those with a standing contract, the telemedicine operator. Ensure as you're getting into that contracting cycle with your clients that one, you include that bit that the limitations, explain to them the limitations of a telemedicine consult. And also as you're beginning that consult, explain to them the limitations of that consult. And most likely, since it is being recorded, that can be extracted. Where you deem your patient is able to understand some text on reading, have a box where they can tick against that, because it is fairly important that there is that mutual understanding. Nelly, is there anything you'd like to add on that?
So we also need to separate. For instance, if a patient is a hospital patient, has come, has had a procedure, is scheduled for a follow-up and they don't come, you reaching out to find out why they didn't come or whether they want to reschedule their appointment is part of duty of care. You not being able to reach them, all you need to do is demonstrate. We need to see the effort that you did your beat. You honored your duty of care. And I have actually seen this work even in public hospitals where they'll actually say patient was called, patient was reached out to, and this was what they said. And it's actually written in the patient file with date and time documentation. That's still part of telemedicine. However, if it is purely just for appointment basis and rebooking and things like that, that doesn't even need to be done by a clinician. But it would be nice to have it documented that, look, patient did not, these are the 3 patients who did not show up for their reviews this Wednesday. And they were called out, 2 were found, they were rescheduled, the 3rd one did not pick. Document. Called at this time, did not pick. Because that then, as I said again, every time you're executing your duty of care, it doesn't mean that you're getting a reciprocal response, but you always must be seen to have done your job from your end, because that's what you will be judged on, not based on how the patient responded to what you did.
Right. Osam, can duty of care be transferred or delegated to another professional? And how should this be done? It is transferable, or when it stops, when, of course, treatment stops and you've documented that treatment has stopped, also through a referral. That is how you transfer duty of care. And where there is need for follow-up, remember the duty of follow-up remains on you. There are instances where patients are not compliant, and that is understandable. But as long as you have documented your thoughts, but also importantly, that transfer process, it is good. If you can call the clinician, well and good, and then it proceeds as such. Does it
also
consent?
additional, so just additional to that is that just because you are transferring does not mean you are exiting. Now, there are times you will be needing to exit. For instance, you admitted a patient, you thought it was a surgical patient, intraoperatively you discover, no, this is not a surgical matter, this is a medical matter, I'm bringing in the physician. And so you're no longer needed. So you need to document that this has been explained to the patient, especially when they're in the ward. So you need to write there in your rounds, patient seen at this time, explained to that this is no longer within my area of expertise. The patient has been handed over to this team or to Dr. XYZ, who is a professional. Dr. XYZ has been informed formally to take over care. And then you actually say, I sign off. Now there you have actually closed your duty of care, but the patient must have also been informed. Sometimes the issue becomes you admit a patient and this patient is they're very attached to you because maybe you have treated them for a long time. And then you take care of you actually find that you actually need to hand over care. The patient is not properly informed. So they assumed that you abandoned them once you had admitted them. So it's really more of a communication issue and on our part, a documentation issue.
All right, can a patient refuse referral, Nelly?
A patient can refuse referral, but you need to document categorically that this is the best, the highest. I remember it's always about the highest attainable standard of care. Now, you need to document everything. This patient requires to see this specialist. Is the patient refusing to go? What are the reasons? You need to document those. Sometimes what we forget is that you say, you need to go and see Dr. So-and-so, the orthopedic surgeon, without giving the patient the option. So it has to start from you require to have an orthopedic surgeon. I would like to have Dr. So-and-so see you. Is that okay? Or would you have your own option of care? So referral is two-way, that you can offer the patient to choose and you refer who they prefer, or you can then be recommending, but with their consent. So once you have put it in writing and they refuse to go for referral, then you do need now to document that and have them sign off that, yes, we have had this conversation. The patient understands why they need to see this specialist, but they have declined. And please document that they have signed that they have declined referral and you put it in file. And remember, just because they have declined does not forbid you from giving the highest attainable standard of care that you can within the confines of what they have allowed you.
All right, thank you. In cases where implants are being placed, is that needed? But also importantly, say cases where the prosthesis that is being used as an intervention, maybe a stent, gets destroyed. Do you charge the patient for the second one? Do you inform the patient about such things? What's your take on that?
So again, having sat in KMPDC for about this is my 11th year, I think, sitting in this committee, I have learned a lot of things. So I actually do put it as part of my consent. I am going to insert an IUCD. I can open the IUCD and the procedure fails because maybe the cervix totally refuses to dilate. I cannot sound, I cannot put it in. So the patient is actually aware that should that happen, they will pay for the cost of the wasted IUCD. You cannot tell them after the fact. You have to tell them before so that they are aware that these things happen. And when they do, then they have to be ready to understand that that cost of care will be transferred. So what we struggle with, again, is just information dissemination.
All right. I will pick a few ones that I think have been relevant to the conversation as we attempt to bring this to a close. The first one is, how do you ascertain that this is the actual person is a legal parent or is a legal guardian or the parent of the child?
Again, sometimes it just requires to be smart. What I have usually done is I ask, where is the other parent and how is their involvement in decision-making with regard to the child's treatment? Again, ab initio, not at the point where you're seeking consent. So if, for instance, a father has brought a child to the clinic and the child requires admission. So as you're discussing what the admission is going to entail, why they're going to the hospital, what needs to be done is where you bring in the issue of, is the other parent part of the decision-making process with regard to the child's care, so that tomorrow if I come to the ward and I don't find you and I find a mom and I need consent, are you okay with that? So normally that kind of puts somebody in a catch-22 because they realize that if they're not the consenting partner, then they need to involve the other party early. And that kind of opens. So especially with people who deal with minors, pediatricians tend to be very, how do I call it? They've done this for a while. They tend to be a lot more able to go around it. But I think the people who struggle the most are our our surgeons who deal with the pediatric age group, because they're so used to dealing with adults sometimes that some things may fall through the cracks. So don't get it lost on you. You're a urologist, you're doing circumcision, Your perception of the child on the table may be very different from a pediatric surgeon who's used to handling children all the time and knows that some of these things can arise. So basically make it clear from the outset, in the event you're not there and the other person is there, whose consent do I need? And most of the time, if they tell you, yes, we are okay, we are both okay to give consent, then you know that both parents have legal consent. Most of the time, the person without consent, if they're the ones with the child, they're likely to realize that they need to be starting to involve the person up front. We also must always remember, legal consent is not the same as the person paying the bills.
True.
So we must separate issues of billing vis-a-vis issues of what clinical care the patient requires and who consents for that.
Awesome, thank you. So in the interest of time, I will just quickly share, I've shared on chat what guidelines for an informed consent should be, and I will just quickly go through it. This is what we expect at KMPDC, and the tenets of informed consent is that there needs to be information, there needs to be comprehension and voluntariness. Just like I said, you need to discuss all these things with your clients or your patients, the risks, the alternative treatments, consequences, i.e. the highest level of skill that is available for this particular procedure, unintended, and also the intended benefits. Comprehension, your patient must understand. If there's any medical jargon, you must decipher that for them. It should also be in a language that they do understand. It must be voluntary and it must be valid. So the person should have capacity or competence to give consent given by a patient or their legal guardian. And they have also received information that allows them to make informed choice. They can also refuse. Documentation is, as you can see, I have shared all these on chat so that you're able to get it for yourselves. We'll also have this on our website at KEHF and also in the various WhatsApp groups, especially by the various associations that we do have. Finally, to our ladies, we see cases where patients or relatives can call in the wards or in the course of you giving care, inappropriate behavior towards the clinician. That should not be condoned, and you have the right to withdraw your participation in the care of that patient. Just because you are the doctor or the clinician and the patients are behaving badly, they cannot and they shouldn't harass you in whatever way or form. Document that, but also more importantly, where you think where you feel that you cannot continue with care and the outcomes could be adverse, it's important to also hand over those patients. That said,
and also, finally, to also consider the security issue. Remember, you're still a Kenyan with equal rights. So where you feel that your security is threatened, you actually do have a right to invoke the security measures within the health institution. And as far as even bringing in the police, please don't be shy, because most doctors can really get abused and they don't realize that they actually have an option. They are put at risk by virtue of their job. You actually do have a right to invoke the security measures that are nationwide and not just at facility level. And maybe one other that I wanted to answer from Princess Mina about a medical officer performing a total hysterectomy because they have the knowledge and there is no specialist on the ground. This is only permissible if it's an emergency. If it is not an emergency, your patient is supposed to be referred. Again, this will be further enforced when we actually see the scope of practice. The problem is that when we start taking on scopes that are beyond our responsibility, what happens is that we make our employers lazy and we actually make them not hire the appropriate skill set for the procedure. So you want to do a hysterectomy as a medical officer, by all means do, but only in theater in the presence of a gynecologist, because ultimately they take overall responsibility should anything go wrong. Now, if anything goes wrong and this matter is brought before council, we are going to ask you, one, was this an emergency? Was it a life-saving procedure in the moment? If it is a postpartum hemorrhage and the patient is bleeding out, you're between a rock and a hard place, you actually get a lot of leeway because it's a matter of saving life. But if it's a cold case fibroids the patient has walked around with for 5 years, and you're here doing a hysterectomy, I promise you, if anything goes south, you are never going to escape culpability. This patient can be referred, even if it means going to the next county. They have a right to the highest attainable standard of care, and you are not it. So let the patient have the care that they deserve.
All right, thank you, Nelly. I think I'd like to come to a close of this. Like we said, a lot of our cases are coming from the OBS and gynecology side. So also ensure that if you're a facility or even a clinician, you've undergone EMOG training, as those are some of the things that will really help with good quality care. Ensure at least you have someone within your team that has undertaken at least basic life support training or even advanced support if you are in a high-risk environment. The other thing is on where laparoscopic procedures are being done, remember videos remain to be the patient records, but also as facility owners, ensure that you store those videos. You don't leave them with the clinicians, especially for admitting clinicians to go and be with. It is also part of your documentation. The other thing is on things like SOPs that are displayed, the talking walls. You need to have talking walls in your facilities and ensure that they are legible. It's 3 a.m. I'm not going to read size 14 on New Times Romans. Ensure they are visible. The other thing is that for some of you, your patient, there are guidelines to this. However, we ask that you desist. At least you should interact with your patients not at least for 3 years before you can start seeing each other when the sun has gone down. And finally, if you're a psychiatrist and you're seeing psychiatric patients, you cannot interact with them socially for life. So we will deem it to have taken undue advantage. That is equivalent of insider trading rather in the stock exchange. That's it.
Also, just one
Find this
minute,
webinar on our platforms. Yes,
one
yes,
last one about
Nelly.
the duration of storage of medical records. I think a lot of people ask this question. Medical records must be stored for at least 20 years. 20 years. But if it's a medical record of a person born in your institution or a person with a mental illness, those records are stored for the life of that patient. So you do not have the luxury of deleting them because 20 years are over. As long as they were born with you, if they live to be 102, you will keep that until they're 102. Or if they are ever attended to because of a psychiatric issue.
Awesome. It's 4 minutes past the hour. I'd hope to have stopped 7 sharp. Thank you all for being with us here. We'll try and keep this on a rolling basis depending on the issues we identify. And if you have any other issues that are touching on this, please feel free to reach out to KMPDC. Any of my committee members remain available. That is Dr. Nelly Bosire, Dr. Elizabeth Gitao, we have Dr. Mbuita, we do have Professor Wanyoro, Lee, Washira, Castina Wori. That's part of the panel that we sit with. But more importantly, reach out to Eunice, who's our Assistant Director in the Disciplinary and Ethics Department. They should be more than able to give you advice on all you may need to know. Let's keep safe outside here. Let's enjoy our Christmas. Let's be diligent in the care we give. Until next time, asante sana, and thank you, Dr. Nelly, for being a sport and being useful in this conversation. Asanteni sana.